Hi, my name is Martha Esch, and I currently own the Lockeport Grill and Fountain, and upstairs of that, the Locke B&B.
Tell me about your experience since you lost your property in a Superior Court case in Sacramento.
Oh boy, well, it's been good and bad, and good. I'm always optimistic that in the end, it's not over with yet, but in the end, it'll all be good. I've learned a lot.
What did you learn?
Oh goodness, I've learned that over time, I think the truth will rise to the top, and it is rising to the top.
In what way?
In the ways of this town, the various stories coming from lots of different people and politics of the town, and the town is changing over time, and I think that there's still hope for the town. It's getting better and better.
For someone who doesn't know the town, how would you describe it in the politics?
For somebody who's new to the town, I try not to describe the politics until they ask about them, and then I try not to give them the full story unless they continue asking more and more questions.
Well, let's say that someone in New York is watching this. How would you describe the situation really that led you to lose your property when you bought the first property, the art gallery, or the property you turned into the art gallery?
You want a quick summary of that
Yes.
the whole debacle?
Yes, because not everyone will know about it.
I will try to give you a 10-minute summary. How's that? Time me.
Sounds good.
In 1990, I came to the town, began painting pictures because I was attracted by the unusual rusticness of the place. The old buildings, it looked like a movie set to me from an old western, spaghetti western. And consequently, Clint Eastwood has filmed some scenes here for his movie called Bird, based on Charlie Bird Parker's life. So in 1990 I came here, started painting pictures of the town and of the beautiful Delta Meadows State Park right behind the town. I noticed in 2005 a for rent sign on one of the buildings, and I lived nearby 7 miles up the river in Cortland at the time. My 2 kids and I wound up moving into the building 3 houses away from here at the top of the hill. I had my art gallery in it and a gift and antique shop, and my kids and I lived in the back of the building and the downstairs of the building. Actually, Lisa Kirk started out renting the upstairs, and then when she moved down the hill to nearby Al the Wops there, I then rented the entire building. So in 2005 I started renting here, and we were given at that time 1 piece of paper with double-spaced typing on it that had the history of Locke. And it wasn't very extensive at all, and I questioned, whether this was really all the history there was to this great town. And tourists would come by and ask us every day, what's the history of this place? And that's all we had to go on. So I started searching out the recorder's office and the California big reference room and the library downtown and the state archives and little libraries all around locally, and digging whatever I could find on Locke and George W. Locke, and started learning a lot. And I made copies of everything I could find. So I made lots of copies of whatever I could find, and then I found little gold nuggets, I think of them as, in the microfiche and in the recorder's office. I found the George W. Locke deed to the original 490 acres here, and that went back to 1893. I found a George Locke biography that was written in 1906, and then I found a book in the Galt Library written in 1954 that made mention that the original name of this town was Lockeport. And I thought, whoa, I've never heard that before. And then there was a mention of the Russian village behind Locke here. And so and I'm finding more and more and more things due to modern technology. Computers are able to scan all these old ancient newspapers and pick out keywords. That's exciting to me to find new versions, or new documented primary source written documents of the history, not just hearsay that doesn't have any citations linked to it. Where did they find this information? And then Lim Mar, who's one of Dustin's relatives, I believe he died a few years ago, but he came to town in about 2008 at one of the spring festivals they had, and he had his book for sale that he made from Historic American Building Survey photographs of 1986. Big, beautiful photo book. I bought one of his books from him, and in the very back of the book was the 1930 census of Locke. 1930. And so I found that fascinating. I started going through it. There were 9 pages to it. The first 2 pages had a lot of people of Chinese ancestry on them. But then, surprisingly, you went to the 3rd page, a whole bunch of Russians and Spaniards. The next page had Italians on it and French people and somebody from Switzerland. And so I thought, whoa, wait a minute. All their literature for the Locke Foundation and the Locke Management Association and their monuments that they're putting up all over the place and their websites, it all says that the town is only about Chinese people.
But did they live in Locke, or were they farmhands that lived outside of Locke?
A lot of the people, this is it, lived in the cannery across the street that is now the boat storage facility. There were a lot of cannery workers, hundreds of them. There's 550 people listed in here, 39 listed as having been born in China, 76 are listed as having been children born in California with one or both Chinese parents. So roughly 1/4 of the population, was either Chinese or Chinese American. But that's not exclusively or nearly exclusively by any means. So when they claimed on their signage that the town was built for Chinese, by Chinese, and exclusively Chinese until very recently, I didn't think that was right to put that, to make those claims when it's not true. I was also told that George W. Locke, the original parcel owner, was a Chinese merchant. And it turns out he wasn't. He was an 8th generation American, born in New Hampshire of English descent.
You got a very negative response to this from the town leaders, of course.
Well, yeah. I would go to their meetings and point out, this new laminated sign you have here, I did that in 2009. I wish you had been there to film it. I said, this laminated sign here you've got with 1-inch letters that says Locke, history of Locke. Locke was built for Chinese, by Chinese, and exclusively Chinese until very recently. I said, how can you say that when there were 23 countries of origin not very recently ago, according to this 1930 census? And James Motlow said, What is that? Where did you get that? What is that? It's the 1930 census of Locke. It's in the back of Lim Mar's book, and you can buy your own. I'll let you look at mine if you want, but you could also get it from the Census Bureau. They were all upset, really upset. And then another meeting, I asked, why do you guys always promote only one race of peoples in this town? It's really been a global village all along. And why do you only why do you say that it's only about Chinese people? And Stuart Walthall said, it's the hook.
It's what?
It's the hook. The marketing hook.
Oh, okay.
But is that what we're going to pass down to our kids and our grandkids, is the marketing hook? You know, I'd rather go with primary source, written documents, and there's a lot of it out there, and there's a lot more to be discovered if you just take the time to go to the different places that have old documents. You can find stuff. It's fun to find these things. And there's also clues in the architecture, and there's clues about the overhead photographs from 1929, and I think it's exciting, and so do a lot of other people that find it exciting to find little things like this.
Okay, let's go to when you bought your art gallery building.
Okay.
You can tell what year that was.
Okay, right.
And what proceeded from there.
So my building that I purchased, first I rented up there at that building I described before. Rented there for 5 years. My landlord, who were the Herringers, sold the building to the owners of Al Lowaps at the time in 2010, the Gianettis. The Gianettis told me that they wanted to come in and, you know, make their office out of it and their home, and so they weren't going to renew my 5-year lease, unfortunately, even after I painted everything and cleaned everything up. But so I moved out, and my friend, acquaintance, more an acquaintance, a little bit of a friend, Laura Ulowitz, who had been a beat poet in San Francisco back in the 70s. She lived in the house next door, which was next door to where I was at the top of the hill, and she had passed away in October of 2007. So here it was 3 or 4 years later, 2010, I moved out of that property, my first art gallery there. And Laura's cousin, Donna LeBlanc in Illinois, her first cousin, called me one day and said, would you be interested in purchasing my cousin Laura's building there? And I said, yeah, I might consider that. She was going to be flying into San Francisco and meeting with her realtor and her lawyer, and they were going to talk about listing the property, and they were going to take a tour through it. And this was in late January of 2011. So they came to town and called me, and I met them over there. The 4 of us walked in, and it was spooky. It was all moldy. Everything was moldy. Windows were broken out of the bottom. Most of the windows were busted out. The back door was jammed open with mud from floods coming in and out of the bottom. It was in bad shape, all rotted out and moldy and cold because it was January. And so we came in, and as the realtor was going down the steps that were kind of treacherous on the interior, a big rat flew by, went like that. And he goes, oh, I've seen enough. Okay, let's go. He turned around, went back up. I stuck my head around the corner anyway, just to peek at it, and then followed them out. And I went down to the bottom of the hill, sat in my car while the 3 of them stayed up at the top of the hill there by the front door, and they talked. And then Donna came down to me, and she said, would you like to make an offer on the building before he puts it on the market or whatever? And I took a deep breath and I said, okay, I'll offer you twice what it's valued at on the assessor's list, which is only $6,000 something. I'll offer you $12,000. She said, okay, I'll go up the hill and see what they say. She went up the hill, she came back 5 minutes later, and she said, the realtor thinks he can put it on the market and sell it for $21,000. Do you want to go up to that? And I said, oh boy. the LMA people don't like me, but okay. And so she went back up the hill and they came back down and they said, okay, we're gonna go to lunch and we'll meet you later and you can write us a check to open escrow with. And so write us $3,000 check, they told me. And I didn't know. Okay. And they said, just write title company on the top of the check. We don't know who we're gonna open the title with, but just write title company. So I did that, handed it to them, and I said, get ready for a bee's nest because the LMA board doesn't like me. And there's supposed to be some weird, the word is that there's some weird thing about you have to get their permission or something to buy a property. And Richard Lee, her attorney, said, don't worry about it. I'm a lawyer and he's a real estate. We got you covered. So, okay. And I didn't know anything about, this stuff. And so 3 weeks later, and they were emailing me back and forth and they hired, I guess, Placer Title Company to open the escrow in Alameda, and the woman was, the Alameda, Allison Botts was her name, the escrow officer. She was communicating with Shirley Roberts, who was the executive director and a realtor with her own company in Galt, regarding trying to get the CC&Rs and the bylaws, apparently. And I didn't know what they were called. I didn't know what CC&Rs were. Never heard of them before. I didn't know that there were any bylaws, but I had been to a lot of their meetings in the past and saw what they tried to, how they treated people who were in transition of buying and selling a property here in the town. I had seen 3 or 4 people go before the board, and including Brady Dresden, who they accepted really well, and she didn't have any problem. They didn't like me because I had already told them that, that they were violating Brown Act, because my friend Lisa Kirk had pointed out to me that, hey, they're a public entity and they have to notice their meetings and tell us what's going on and allow us to participate in these meetings. So I started to learn about Brown Act way back then, and a year before I bought, the property. And so I saw how they violated Brown Act left and right, and told us that we weren't allowed to speak until the end of the meeting. And she, educated me somewhat at the beginning on Brown Act. Since then I've learned a lot more. So I waited for those CC&Rs and bylaws to show up in the mail, and they were notified by Allison Botts at Placer Title Company on, I had all these dates memorized. I believe it was February 8th at 4:19 p.m. There's an email from Allison Botts to Shirley Roberts, and that saying, we have an open escrow on 1265 Levy Road. Please send the H.O.A. docs. Shirley Roberts then emailed her back 22 minutes later, same day, February 8th, 2011, saying, oh, Allison, we have a board meeting tonight, and there's a technicality that has to be dealt with on right of first refusal. And I'm paraphrasing here. And I'll send you the docs tomorrow, or something like that. And then she didn't send them tomorrow. She didn't send them for like another 2 weeks. She finally sent them close to the end of February. And they had that meeting that night. I went to the meeting on February 8, 2011. And I attended the meeting. And at the end of the meeting, I left the meeting, went out and started walking up the street. Shirley came out of the meeting, chased me down. She said, oh, Martha, I just want to let you know that Allison Botts emailed me today and she said that you're buying that property up there, is that right? I said, yeah, why, Shirley? She said, well, you're going to have to go before the board next month and ask for permission to buy it. But Shirley, you know the board doesn't like me. They're not going to want me to buy that property. Well, either you or your realtor, you will have to go before the board. Okay, Shirley. And then I got these CC&Rs, and first thing I did, I went over to Lisa's shop down there right next to Al the Wops, showed Lisa. We were looking for this clause in here. We didn't know it was called right of first refusal or anything, and well, except for, we saw it in that one email. We were looking for the time limit because everybody was saying it was 30 days. Within 30 days, the board can make a decision as to whether they're going to buy the property or not, or assign the property to somebody or whatever. It wasn't 30 days. It said 25 days. Board has 25 days from the time that they are notified. So we went back to, okay, they were notified by Allison Botts at 4:19 p.m. And then the next day they were re-notified by Richard Lee, and they were sent it by FedEx and by UPS and by stool pigeons. I don't know. They were sent it a number of different ways. Notification that I had an open escrow on the property, and Donna LeBlanc, the seller, actually, she was the administrator of the estate, and the bylaws say the owner of the property has to notify when they are selling or putting it on the market. Well, the owner of the property on title was Laura Ulowitz, who passed away 4 years earlier. How's she going to notify them? Anyway, they all tried to notify them, and Lisa and I got out the calendar and counted down from how many, 25 days. And it wound up with March 5th. They had to meet the terms and conditions according to the bylaws, or the CC&Rs. And the bylaws and the CC&Rs work together on that right of first refusal clause. So they had till March 5th. So I started going down there to that board every 2-3 hours. Their public notice board, because they're a public entity and they have to post a notice if they're going to have a meeting. They have to post a notice, a regular meeting within 72 hours, an emergency meeting. This wasn't an emergency, but they could call it an emergency. They still had to post a meeting notice within 24 hours if it was an emergency, and a special meeting, I believe special meeting is either 48 or 72. I'll have to. So I was looking at that board every day, more and more, as it approached March 5th. They only had 25 days, so they had to March 5th, and Attorney Richard Lee for Donna LeBlanc had sent them an email that they then forwarded to me. They kept me in the loop, stating that they had until March 5th, and then after that point, they couldn't exercise their right of first refusal anymore. March 5th came and went. They never posted anything. On March 7th, the day before March 8th, they posted a meeting agenda. They were late. They were 2 days late for posting a meeting agenda, so they already violated the Brown Act once there. On March 8th, there was a full house of people at that board meeting. I was usually the only one in the audience, or one or two other people, with a fairly large board at that time, showed up for those meetings back in 2011. But it was standing room only on March 11th. Somehow, how did the word get out? This is interesting. Also, board member Ernie Wester, nice guy Ernie, I like Ernie. He probably unknowingly went around, took it upon himself, along with my other friend here, neighbor, Tony Lee, and they went around with a handmade petition. Do you want to, should the LMA exercise, and buy that building, look, and they went around to just specific people in the town to get them to sign. He can't do that because that's I know, it's not right. And that was brought up at the meeting that it wasn't right. So they held their meeting on March 8th. They were already 3 days late, right? They had 5 board members present at the beginning of the meeting, and they were actually they had 6, because they had the state parks lady, Kelly Clark. She sat in at her board seat at the beginning of the meeting, so they had 6 people of a 13-member board. They claimed that Tony Ragona had submitted his written resignation the day before, but they didn't include that with the packet or anything. So they only had 12 then at that point. So they said that they only needed 6 to make a quorum. Wait a minute, 6 is half of 12. A quorum is 51%. So they needed that 7th person. They only had 6, and then Kelly Clark said, oh, hey, you know what? State Parks doesn't want to be any part of this, so they just want me to be advisory from here on out. I'm going to go sit out there in the audience. So she got up, she went and sat in the audience. This is all on transcript and stuff, too. And then they were getting busy calling. They tried to call Brock Alexander. Hey, Brock, do you want to come down here and sit at this meeting? Couldn't get him. They called Dustin Marr, who was next building away. No, I'm not coming. And so they called Daryl Wu, too. Daryl, get down here. Come on, we need you. We need you to make a quorum. They waited. He came in an hour and 6 minutes into the meeting. Before he came, they made action votes to approve their treasury report, to approve the minutes of the last meeting, to do this and that. Minor stuff, but they were still action votes. That's a violation of Brown Act. You need a quorum. And if you read their bylaws, it says a quorum is the majority of directors holding office at any point in time, comma, initially present at a meeting. Daryl Wu wasn't initially present. He made the 6th board member. They still needed 7 board members for a 12-member board if one of them quit the night before. I knew they had violated Brown Act on the posted agenda, on the lack of a quorum, and I knew that they were already 3 days late to exercise right of first refusal. But they always shouted me down at meetings anyway, and Lisa said, shut up, don't say a word. Just let them make their board actions, and then, you know. Richard Lee, the attorney for, you know, he said, I said, I'm going to go to that meeting tomorrow. Do you want me to, you know, record it? And do you want me to say anything? No, don't say anything. Do record it, don't say anything. So, okay, what do I know? So I didn't say anything. And then, so they held their board meeting. They waited for Daryl to come in. And then they said, okay, Daryl's here. We can go back to, agenda item blah, 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 where it says right of first refusal on the 1265 Levy Road. And then the next agenda item was right of first refusal on the property on Main Street for active tenants in that property, income producing property close to Al the Wops, you know, the center of town. But they didn't discuss both properties together to figure out, okay, where would be the best place to spend our treasury funds. That one was only $38,000 on, and the one, you know, I was in escrow for was $21,000, but it needed a heck of a lot more work than that one did. But they had already made up their mind that they were going to do what they can to exercise right of first refusal on 1265 Levy Road. So when Daryl came in, he advised them, and Brady, they were the 2 lawyers, right, on this 13-member board. Well, they didn't have 13 members, they only had 6 again. They discussed it for 20 minutes or so, and Brady said it was very uncomfortable. She said, you know, we really should be discussing this in a closed-door session because it deals with property. And Daryl said, well, we could exercise, I'm paraphrasing again, we could exercise right of first refusal, except I think it expired yesterday by our time period. And then Brady said, no, I think it's tomorrow. Depends on how you add it up. And then Daryl said, and I recorded this whole thing. So when I got home, I listened to my tape over and over again. I couldn't understand this one thing that Daryl Wu said. He said, so we're Muyo Kopo on the date. And lawyers will disagree all the time and blah, blah, blah. But let's go ahead and exercise, or let's go ahead and vote, take a vote, a roll call vote, and then we can let the lawyers figure it out later or something like that. But he said, well, Muyo Kopo, and I listened to Muyo Kopo, what is Muyo Kopo? So I typed in Muyo Kopo, and Google said, did you mean to say mea culpa? And it sounded, that's Latin. I could tell it was Latin, but I didn't know what that meant. So I looked up mea culpa, and it said, like, my bad, I'll defer to you. It was a lawyer term, I thought that was interesting. There were mea culpa on the date as to the 25 days, the 30 days, but none of them had a bylaws or a CC&Rs with them to look it up and really examine what it actually was. I knew, but again, I was just told not to interrupt the board, and in the past when I had said things at board meetings, I just got shouted down or kicked out, or they don't like me. So the following day, Richard Lee, the following day, late in the afternoon, Clarence Chu, probably with the help of some lawyers, sent a letter to Richard Lee, Donna LeBlanc's attorney, and he said, last night, again, paraphrasing, last night we held a board meeting and we decided to exercise the right of first refusal on 1265 Levy Road, so let's get together and we'll give you the $21,000 for that property. It was sent late in the afternoon, so this was what? Not the 25th day. This was the 29th day after they were notified by Allison Botts of Placer Title Company, in the next, so he sent that, and then Richard Lee sent him back an email, and again, FedEx package, and sent it lots of different ways, saying, sorry, Clarence and the LMA board, but you guys are late by your own rules. I warned you by email that March 5th was your last possible date and to exercise right of first refusal, and we're going to do the right thing and the legal thing and close with Martha's name on that property. And then they forwarded all these communications to me through email. And I'm like, wow, okay. Next, what was it, March 26th. So that was about March 11th, that kind of stuff. March 8th, 9th, 10th, 11th, and then March 26th, or March 15th, my escrow finally closed. March 21st, 2011, my name was stamped on the title by the recorder's office. Martha Esch owns 1265 Levy Road. Oh, phew, good, phew, hooray. March 26th, 5 days later, Clarence sends out a letter, Clarence's signature, but he didn't write it. It was written all kinds of legalese and stuff. But it had Clarence's signature on the bottom, and in that letter he said, there was a critical paragraph in it that said, our responsibility on the board is that we must notify 400 Chinese ancestors and descendants due to their own priority to purchase the Locke property. Unquote. I took the letter over to Lisa. Lisa read it and she said, "They can't say that. They cannot say that. They said that that's discrimination. That's against the Constitution. They can't say that." She got on the phone. She called HUD in San Francisco and said, "You got to help my friend Martha. They're trying to take her property." And look what they said. HUD called me and said, "Do you want to file a complaint?" And I didn't know what a complaint was. I thought, your shoes don't fit. You go to Sears and you say, "Want to talk to the complaint department." That's what I thought a complaint was. I didn't know it was a lawsuit, and it was never told to me that it was a lawsuit. It was a complaint. So they said, "Okay, well, go to your computer." I don't have a computer. "Go to the library." Does the library have a computer? Yeah, they have. So I went to the Walnut Grove Library, 2 miles away there, and they faxed me 21 pages of fine print, right? The guy talked to me on the phone, and I told him basically, I'm just complaining about this one sentence in this letter that says that there's a priority and they want to take away my property from me that I just bought. And they had their 25 days. Why are they saying this? And nobody else in the town, they haven't told anybody else in the town that that their properties have to be given to 400 prioritized, a priority list. That's not right. And
So did it say Chinese in the letter?
I quoted you exactly that. ... Our responsibility includes that we must notify the list of 400 Chinese. It said Chinese. It didn't say the anybody list and the interested parties list. And if you read their bylaws and CC&Rs, they don't have to. There is discrimination there too.
But in the actual CC&Rs, it does not say Chinese, right?
Let's see. The bylaws is where there's a set of bylaws and there's a separate 32 pages of CC&Rs. The bylaws mention shall be, you have to go match this up with section 2.8 of the CC&Rs. And in the bylaws, there's a big paragraph at the top of one of the pages. It says, I can't remember the title, but it might be right of first refusal. It's in the bylaws. And it says, due to the injustice of the alien land law of I'd have to read it again, but it mentions the word Chinese 5 times within that paragraph, talking about the terrible discrimination that happened. Truly it did. And that the board shall consider, or the board's responsibility is to then try to help alleviate that terrible discrimination that happened to those folks by A, B, C, and D. A was something like establish a list of and create a display or something talking about the discrimination and put it in a museum or something like that. B, C, the D is where the discrimination is. Oh, they had to also maintain a list of and update. In C was, I think, updated annually. This list of ancestors and descendants of Locke. Now, in that A, B, C, and D, it didn't mention the word Chinese, but in the preceding paragraph above, it did 5 times, and it didn't mention anybody else. So D was consider this list as a factor in the assignment of right of first refusal as talked about in the CC&Rs. That right of first refusal clause also is duplicate in the Locke Foundation bylaws. It also, but they don't have a set of CC&Rs to go along with it. But it's right there front and center. And the board, the 13-member board of Locke Management Association is also supposed to be seated by the same exact individuals of the Locke Foundation, both created by the Sacramento County Board of Supervisors by resolution, big rubber stamp, 3-2 vote of the supervisors on May 13, 2003. It's in the recorder's office. That's the most important document there is. And that document does not define Locke Management Association as a homeowners association or as a common interest development. The closest it comes to that is by stating that one of the purposes of Locke Management is to maintain the common areas of the town and the public areas of the town. We're not a gated community here. We encourage the public to come here, and it is a public agency, governmental legislative body that created us, which is why they have to comply with Brown Act, open meeting law, to allow transparency and participation of the public. The discrimination clause is not in the CC&Rs. It is in the bylaws, A, B, C, and D, D of that right of first refusal area, where it says that they've got to have two lists. One is an interested parties list, and the other is the ancestral list, or, the list. But only the ancestry list has to be consulted as a factor in the assignment of right of first refusal, unquote. The problem with that is that equal protection clause, U.S. Constitution, it says you can't. I think they're doing that on purpose out there, the weed eater. The right of first refusal clause, anyway, it contains that discrimination, and they can't discriminate for property purchases based on ancestry, race, national origin, religion, handicap, or let's see, what else? Sexual preference, gender. I think that's all.
So you got your complaint filed?
Oh, okay. So the HUD sent me 21 pages, and they wanted me to simply sign the bottom of each page and fax it back to them. And so I did that. And I guess that, I was thinking, okay, that's a complaint, like, okay, I'm complaining a little bit, but that opened, then they sent a lawyer to town who went around and interviewed the bartender and everybody in town who didn't know beans about anything that was going on, but they interviewed them anyway. They interviewed me, they interviewed Lisa, I think they interviewed Diane Thomas, who has the acupuncture shop down there. I think they interviewed Clarence. Yes, they interviewed Clarence, and they asked him about this sentence that I was complaining about, that he signed, saying that there was a priority for 400 Chinese people, and since Martha's not Chinese, we get to take her property away from her. And he said, "Oh, I didn't sign, or I didn't read it. I simply signed it." Well, for the next 6 or 7 or 8 months, whatever it was, that they were figuring all this out in San Francisco. They didn't give us any sort of a trial or anything, and we were just waiting for this report to come out. And then they came out with an 8-page report, and within that 8 pages it says discriminate. Basically, we can't prove that discrimination actually happened because Clarence Chu said that he didn't actually read the letter that he signed that Martha's complaining about. He simply signed it. So they were let off the hook. Meanwhile, back on April 12th, right about, I think, either the day before or the day after, I signed the bottom of that HUD complaint and faxed it back. I got a letter from Locke Management's lawyers, BPE Law Group, Stephen Beatty, the head of his law group company. And he said, hey, we understand that you bought the building and that you're making changes to it. I was cleaning it up and repairing and applying for building permits right off the bat, and I had already gotten my business license for it, for my art gallery, to move my art gallery over there. Locke Management, my client, Locke Management, objects to this, and we'll be really nice and we'll offer you the same $21,000 that you paid for it. And if you refuse, we're going to sue you for it, and you could be put in jail and blah, blah, blah. And it's like, dude, I could go to jail for having bought a property, and this guy's threatening me. And he said, and if you don't reply to this within 1 week, something like that, you're going to suffer I forgot what it said, but you had 1 week or something. I replied and I said, and I replied right away and I said, here's my reply in this attachment. And I simply attached the digital copy of the HUD complaint to it. You said that there's a list of 400 people that I don't fit on that list, so I don't get to own the property. Here's my reply. That's what I said. That's all I said in my email. Here's my reply. Boom, in the attachment. Long attachment that HUD, sent me, that I just signed the bottom of that HUD complaint there, complaining about that other letter that Clarence had made on March 26th, saying that, basically I didn't fit the priority list to buy a property. And then the next communication that I received from them was a knock at the door, and they served me with an inch of paper sometime around May 20th, which is when they filed to sue me for violation of right of first refusal, and they sued Donna LeBlanc in Illinois, the co-defendant, saying that we both violated their right of first refusal, and that that we were violating the CC&Rs, and okay, well, really? And now here we are 10.5 years later, and we're still in court.
Okay, so what's been happening since the judgment that took away the property? This is like chapter 2 of your life. Then where did you go from there?
Okay, the judgment. Well, there's so much to this. I mean, we could talk for hours just on all this.
But just
legal
steps.
Summary.
There are steps.
Steps. I hired the wrong lawyer. I didn't realize he was the wrong lawyer until after Judge Brown made a motion for summary judgment, which is important because it denied me from a fair trial. He made his own motion for summary judgment. My lawyer failed to answer the points and authorities, and my lawyer argued that I don't have to answer their points and authorities because look here, they have a technical flaw and code section this and that, and the judge didn't agree with that, and so the judge said, okay, since you didn't argue, and since Richard Lee, the co-defendant, is not posing any argument to them saying that we get the property, then they win, and Martha and Donna lose. And so, bam, that was February 7, I think, of 2015 or 16? 2016. Right around there, or March, either February or March, he made that judgment that they win, I lose, and Donna loses, and Martha has to hand over her title, basically. And they're the prevailing parties because he determined they were. Their CC&R say that the prevailing party has to pay legal fees, so a month later they filed, okay, now we want $250,000 from Martha and Donna for our legal fees for the last 5 years. So I was still in my art gallery. I had improved it $80,000 worth. Judge Brown, in his motion for summary judgment, said I was only entitled to that initial $21,000 because he determined, without asking me and without asking my lawyer or allowing me to speak, I was told I'm not allowed to speak, and you know how hard that is because I love to talk. But he said at that motion for summary judgment trial, where he determined without allowing a trial of my peers or anything, he determined that because Martha didn't object at that meeting, because she stayed silent when she saw they were exercising right of first refusal, why didn't she jump up and say, hey, you can't do this, I want, that's not fair. She didn't say that. Because she didn't object, she only gets the $21,000 that she paid for that. She doesn't get the $80,000. Again, I'm paraphrasing, I'm adding to it. But he determined that I wasn't entitled to the $80,000 I sunk into the property for building permits from the county, same people that created this board and everything, for all the rot repairs to the rotted out perimeter of the building. The porch had fallen through, busted windows that I replaced with antique windows downstairs. It was a mess. The plumbing repairs, electrical repairs, 3 or 4 different building permits. And the first sign permit, I think the one and only sign permit ever gotten in the history of Locke for that building, that the C5, I call them, Crony 5, the Crony 5 Club, argued and tried to deny me from being allowed to mention the word Lockeport on the sign, and George W. Locke. They didn't want me talking about George W. Locke because it would ruin everything, whatever. So they fought, and then those permits that I applied for, but I did get the building permits. I put in a redwood deck. I put in a wheelchair ramp entrance.
Yeah, tell me about how they destroyed that after you put in that.
After I put in the beautiful redwood deck with a gorgeous ramp going down, and I applied for the door. Oh my gosh, the door was highly contested because it was my door, because it was Martha's door, and Martha wants to change the history of Locke by adding this door to Main Street with a wheelchair ramp. And oh, nobody's ever had a wheelchair ramp entrance. That would change the history of Locke. You can't do that. Meanwhile, if you go around the town, count all the Home Depot doors that are on these a lot of buildings here with no permits. Count the corn cob smoke that the pipe from corn cob heaters that were put in illegally with no building permits. See how many people have turned in their single family homes into duplexes around here. Mostly board members done that, and with no building permits. But Martha can't put in this Main Street door that she's going to use, which I did use, the same fabric that came off of the batten board historic building. Saved that, and I fronted a door, made it look like it had been there 100 years. It was really cool, and it had a wheelchair ramp entrance off of Main Street. And it is a commercial/residential building. And the guy up at the top of the hill always screams and yells at the tourists when they come up there that, you can't go in there, this is a private street. Well, he's living in a commercial property too. But anyway, so they didn't want me to have this door, so I had the door. And I put in my little museum, history museum with a lot of George W. Locke stuff that I've found. I've got stacks of those historic documents that I found here and there and everywhere and make copies of. And I wanted people to be able to see, these are some written documents of Locke. So there's more than one story to this town.
So what response did you get from the public?
Awesome response. Awesome. But it was only open for maybe a year before Judge Brown said, okay, she's going to have to move out, and their attorneys gave me a 3-day notice to move out. My own property that I had paid taxes on and upgraded, and really, had my art gallery established in it, and I had an apartment downstairs, but then, so a few months later, and you've got this on your videos of those meetings. They discussed at one of the, I think it was a 2017 meeting, somewhere around in August or late July, they discussed that they were going to, now that they had the title, they being the Locke Management Association, and they paid me what the judge told them to pay me, which was only $21,000. Not the extra $80,000 or the amount that I had increased the value on of the home, and they paid for me. They paid that check with a treasury check from the Locke Management Association, which doesn't belong to the board, belongs to the 38 property owners here, or 32, whatever there are. There's either 32, 38, depending on who's buying and selling a home at the time. They paid those $21,000 with a check from that treasury account without having any board meeting about it, without asking any of the new owners of the property, it became common ground property basically after the property was signed off to the Locke Management Association. It was signed by the judge's clerk, bottom of my title, signed and given over to them. But it wasn't given to the board, it was given to the association, which includes the 30 some property owners. Nobody in the town was told about it, other than the board members, had their own little meetings, probably in violation of Brown Act. And then they held a board meeting, I believe it was in July or August of 2017, 18, somewhere in there. I don't know, I have to look at it again. And they had a right of first refusal on the agenda for 1265. They already had somebody picked out, I'm pretty sure, that they wanted to own it. There was a gentleman from, I believe he was from like Tracy or somewhere south of here. He was a Hispanic gentleman, and he stood up at their meeting. He said, "I want to put my hat in the ring for that property because I'm an artist, and here's my portfolio." And he passed around his magazine stuff with his artworks in it, and said, "I want to put my hat in the ring for that, and I'd really like to get that property. And I've been coming to Locke for a long time. I love this town, and please consider me, and I'd like to, you know." They went in the back of the room, closed door session meeting. It didn't have anything listed, you know, properly on their agenda as to, you know, but they went into the back of the room and already had their mind made up. He didn't get it. I made a statement at that, and I said, "It's, you know, way wrong what you're doing," or whatever, and the 32 property owners haven't been notified that their property now, their common ground property, you guys are putting up for sale without a vote from them. Anyway, and then I believe it was at the very next meeting that you recorded, Jean, you recorded Shirley Roberts, once again, being invited to that meeting. She went into the back boardroom with them, just like she did at some of those meetings when Brady Dresden went in there. And I've watched your videotape of Brady Dresden. She said, you know, people went into those closed door session meetings who weren't board members, and that wasn't right. Well, we saw that, and I think you asked me about that. Is Shirley Roberts back on the board or something? And they didn't anyway. So it just goes on and on.
Well, let's talk about what's happening right now. This is October 19th, 2020.
2020. Okay.
2020. What's your goal? What are you doing legally to...
Don't ask me too many questions. I go off on. Okay. What's happening now is in 2020, October of 2020, is my appeal with the 3rd District Appellate Court that I filed way back in 2018, I believe, or no, excuse me, way before that, 17, I think, 2017, when they say they want legal fees from me for $252,588.59. I've got that number memorized because 1 year ago, I got a call from LMA's lawyer saying, "Hey Martha, let's get together. We have a mandatory settlement conference assigned to us from the appellate court on the Donna LeBlanc appeal." Donna LeBlanc, the other defendant. And I said, "What? Donna LeBlanc has an appeal? What? What are you talking about?" Here I am in 3rd District Appellate Court for like 2 or 3 years now. I didn't know Donna also filed an appeal. Are you kidding me? Oh yeah, well, it goes back even before you bought the property. Something about her probate case with Laura Ulowitz, her cousin. What are you talking about? Oh yeah, it's still open. They haven't been able to close the probate on. And is there a case number for this? Give me the case numbers. You know, so I wrote them down. I went over to the probate court here in Sacramento. Asked the clerk can I pay you to print out this? Sure, no problem. Public information. Printed it out. Handed me an inch of paper. How come there's never been a notification to us 32 property owners that the LMA has hired BPE Law Group and is paying them to fight this lawsuit? And it's even older than their lawsuit, including me.
And were they charging you for that or her?
Apparently so. I don't know. There was an awful lot of black magic marker redactments on like 50 pages of itemized little tiny billings when they went to Judge Brown and said, look, Martha owes us $252,588.59. Apparently, so this is the first time I've heard of this, and this was July 26th of 2019, just last year. This is, we're talking 10 years later, right? Or 9.5 years later, something like this. A different judge, not Judge Brown, but Judge John Wynn, in the probate section of Sacramento County Superior Court. I read his order, and he ordered that Donna LeBlanc, okay, Judge Brown says Martha and Donna jointly and severally must pay, I think it's $202,588.59. It's the most recent amended order. Judge John Wynn says Donna, all by herself, must pay $202,588.59. What? Wait a minute. Same thing, but nobody's told us about this court case. This one, it says that she and I both have to pay it. I say it's really wrong why you're saying, because you guys discriminated against me, and that maybe could go all the way to the, if the appellate court disagrees, it might still be contestable in the next higher court, the California Supreme Court, because it originated with discrimination from a public entity that should have done inverse condemnation. There's nothing in their initial articles of incorporation that they filed with the Secretary of State that say that they're a homeowners association or a common interest development. That stuff didn't come until 5 years later when Clarence Chu filled out a form checking the box saying that it's a common interest development and has to comply with Davis-Sterling Act rules. The Brown Act still does apply because they were created by a legislative governmental agency that the state created, the Sacramento County Board of Supervisors, and they were created by resolution to be one 13-member board of directors to govern, is the word in the resolution, govern both the Locke Management and Locke Foundation.
To bring us up to the very current, tell us what happened with all the directors resigning except one.
Oh boy. Well, before I tell you about the directors resigning except for one, July of last year I find out that there's two different judgments. I was just about ready to submit my appellate opening brief, and I'm self-representing now because, frankly, learned a lot from the law libraries. And while I'm not saying that I'm any great attorney or anything, and I'm not an attorney, I don't profess to be an attorney or to know a lot about the law, but I am finding out and learning what I need to represent myself, because nobody knows this stuff better than me. And if we do go to court, I want to be able to argue it, whereas my lawyer didn't say the things that I wanted him to say, and Judge Brown scolded me the 2 or 3 times when I tried to interject something. Hey, you have a lawyer, let him talk for you. And it's like, I want to be able to at least voice what I know to be correct and what I have read to be the way it's supposed to be, what I've learned. My appeal, I filed my appellate opening brief, and I filed my reply. They filed a reply to my appellate opening brief. And again, they're arguing all this, and they're probably charging the association, and they're on retainer apparently for $1,000 a month for the last 10 or 11 years now, because there's a budget deduction minus $1,000 for legal stuff.
Don't you think the LMA must be broke now?
I think that they're probably deeply in debt, possibly to $202,588.59 that they think they're going to get from me, and I'll fight tooth and nail to keep them from taking this place away from me just because they think that they can, and charge me for 9 different, I think there's 9 different cases, small claims cases against 5 different people that they have never once put on a posted notice to the public saying, we're going into closed door session to discuss legal case number blah blah blah, and lawyer X will be present. That's required. They haven't done that. So they've been violating Brown Act all along, and they continue to violate Brown Act. And in June of this year, which is, today's October, right? So a few months ago, I got a notice through my email that the appellate court was noticing me that a settlement has been made with Locke Management Association and Donna LeBlanc in her appeal for the same $202,588.59. So what? How did they make a settlement? They haven't held a board meeting in over a year. The last board meeting that they held, that was a legal board meeting, kinda, but not really, was in July of last year when Don Natoli came down here. You filmed that one too. So it's been over a year since they've held a board meeting. How did they come to a settlement agreement with Donna LeBlanc over the judgment in her probate case and the judgment that she's also appealing, that Judge Brown made? How did they do that? And how much was the settlement? Oh, we can't tell you. That's privileged information and stuff. When was the board meeting? When was the board action? And who's on the board, since everybody quit last July and August and in February? One of the guy that Don Natoli assigned to represent the county, he even gave it up. He said, hey, I can't call a board meeting because there's no quorum left. Everybody's quit. Daryl Wu claims to still be on the board, and the county endorses him. The county wrote me an email and they say he's still on the board and his seat doesn't expire until December 31st of 2020, coming up. He's still on the board. We say he's still on the board. We appointed him. Okay, really? Show us that notification. And apparently the board, the Daryl, I'm guessing here, the Daryl had a unnoticed to the public. He is the public entity of Locke Management at this point. By the way, he also sits on the Locke Foundation, which was created, anyway. Apparently he had made a settlement agreement without posting it to the 32 property owners here, publicly on the little board down there, or letting any of us know, to allow Donna LeBlanc's $202,588.59. They settled to, she only has to pay us $25,000.
So how did you find out the 25,000 number?
I went down to the court, third appellate, asked for a printout. There it is. Public information. I called Mr. Enos, their Locke Management lawyer. Hey, Robert, am I off the hook here? You still? Oh no, we figure we can. No, you're still liable for the balance. Oh really? So Judge Brown says that Donna and I have to pay jointly and severally $202,588.59. I don't agree with his judgment at all whatsoever, but he says that we have to split it down the middle. This other judge said that she had to pay everything, and now you guys say in violation of Brown Act. Hello. That Daryl Wu, apparently, I don't know, they're not admitting to it. And Daryl Wu won't answer emails. He won't answer certified letters from me. He won't answer public record requests. He won't answer telephone calls. All these many, many months.
How about the supervisor, Don Natoli?
Oh, I have written to Mr. Natoli, who I like. He's a great guy, real nice guy. But I have written him over 200 emails, mostly apprising him basically of what's going on. You know, when stuff happens here, I've let him know. And for the last year or so, I've been carbon copying all 5 of the Board of Supervisors because Mr. Natoli has never once in 10.5 years replied to my emails. And he has only given me 2 in-person conferences with him in his office.
Is there anything else you'd like to say before we wrap?
You were asking me to bring you up to current day quick summary, and I've skipped over an awful lot of details, but it's mind-boggling. In October of 2018, 2 years ago, I filed a Brown Act writ of mandate on the LMA, the Locke Foundation, and the Board of Supervisors, the Sacramento County Board of Supervisors. I filed a writ of mandate for recent Brown Act violations that they made back in June, July, and August of 2018 ongoing. I gave them a 30-day cure and correct period. They didn't cure and correct. They didn't, I gave it to all 3 of the respondents. No, the county gave me 1 meeting with their county council and county executive and the county director for about an hour, and Mr. Natoli came for a portion of that too. Basically, they said, we got nothing to do with LMA, we're not them, we're not violating Brown Act because you got your problems with LMA, but we can't do anything for you because we're not LMA. Their lawyer that they hired, a third-party lawyer, convinced me on the telephone to drop the county from my writ of mandate. So I did so without prejudice, where I can put them back onto the complaint, and I'm about to, because the county is now obviously acting on behalf of a board of Locke Management. On February 5th of 2019, a few months after I filed this Brown Act writ of mandate back in 2018, the county rubber stamped allowed the Locke Foundation Board of Directors to separate, including our rights, the 32 property owners' rights to elect our representatives on the 13-member unified board that's supposed to govern both the Locke Management and Locke Foundation. They basically changed the Locke Management Association rules by allowing that separation and allowing them to become a private nonprofit, whereas Locke Management is still a public nonprofit. And yet Locke Foundation has pretty much claimed all our little parks here, common ground parks, planted monuments and things that turn them more into sanctuaries instead of playgrounds or places for the community. There's nothing, and given them a big portion of our community gardens and built fences and things and done, on our last little bits of community parks here. So the Locke Foundation, early September, just a little bit more than a month ago, I filed another Brown Act writ of mandate to apprise the court that, hey, there's this $25,000 settlement that supposedly there was a board meeting about, but they violated Brown Act by not posting a public notice that they were going to have a settlement agreement and legal talks and lawyers and stuff and come to an agreement over this big judgment of $2,588.59. Where was that board meeting? Hello?
Have you done any research about Brown Act where any city has been financially fined for violating the Brown Act?
There are not a lot of Brown Act cases out there because there's like a $500 per Brown Act. And I got a long list of, if you want to number them all out, code section this and code section that, violated by not posting the notice, by, 500. But there's also a clause in there, and I don't know, haven't found a case on it yet where criminal charges, but there is misdemeanor charges if directors knowingly violated Brown Acts. I didn't file these my intent isn't to make a lot of money, okay? But my intent darn well is to keep what I still have here. They can't take this place away from me because they wanted to, and they say that their lawyer, and Martha has to pay for all the lawyer fees of all the different cases they've had against different people in this association, but it's all on one bill apparently, and I shouldn't have to pay for the first match. And here's another thing, it's really important. This is part of my appellate opening brief, and my argument is that they are public entity. They were created by a public agency. One of the big rules that I've learned since the property was already taken away from me was public agencies and entities must offer what's called ADR, Alternative Dispute Resolution, prior to suing somebody. They never did that. The closest they came was with that threatening letter that Mr. Beatty sent me saying, we'll offer you $21,000, and if you refuse, we're going to sue you and put you in jail and blah, blah, blah. That was not an offer of alternative dispute resolution. The next thing I got from him was the lawsuit. And I think Donna LeBlanc in Illinois got the lawsuit, or her Alameda, Mr. Lee, the lawyer. They weren't offering her alternate dispute resolution either. That's a real important thing. That's fundamental.